Do we have an adequate legal regime, and should the same standards apply in relation to plan making? We're going through one here with Mary River present. So you can see in section 15 of the current provisions, paragraph A, that allowing for allocation of water and contributing to the fair, orderly and efficient allocation of water to meet community needs. We have to look at reversing degradation of watercourses, lakes and springs. So that's a positive obligation to reverse something and contribute to the confidence of water users regarding the availability and security of water. As a farmer, I'm not sure how you're meant to be confident in relation to security of water with the rules the way they're currently written. And also having community understand and participate in the plan making. When we were in Gallo and Williams, one of the things that we put to the court was, you've given allocations to people who've got no irrigable land, and yet you're making us, Gallo and Williams, go to this cost and this extent to get an allocation. That's not fair. And we were actually asked by the court to put in supplementary submissions in relation to that fairness argument. And the court accepted that there was an element of that required as a result of the legislation. So here's the Minister's performance assessment of the current plan. This is the government saying this is our scorecard. 23 general outcomes were identified. 6 of those were said to still be high risk. 1 was medium risk and 13 were low risk. But you know what? We didn't have information about 3 of them. This is one of our most precious assets, and that's the report card from the state government. They identified these following defects. The plan currently limited the future agricultural expansion. New science have been collected in relation to the needs of Mary River turtle, Mary River cod and lungfish. The importance of the water resource to the Aboriginal peoples and their strong spiritual connection to water. Establishing a water market for tradable water allocations, and I'm going to talk a little bit more about those tradable water allocations. Plan lacks flexibility to accommodate changing demands. There's an awful lot of inflexibility in government. The plan has a specific outcome, which is to encourage the efficient use of water by having a tradable market. Now, many of us will have different opinions about whether that's a good thing or a bad thing. The argument for having a tradable market is the water will then be traded to its highest and best use. I don't agree with that entirely. I think that will happen in some instances, but there are plenty of other instances where that won't happen. And one of the things that was spoken about in the tragedy of the commons, so those things which are common rights for all of us, is there is a difficulty around those things because sometimes it works and sometimes it doesn't. There is no clear one answer. If we go to think about what happens with consultation with these plans, first of all, do I trust and rely upon the modelling that the government has put forward? As a lawyer, I've seen too many instances where that modelling hasn't been soundly based, so I have difficulty with that. That's part of my profession. I have to look at things in that way. If we're looking for efficient use of water across that whole Mary Valley area, how has that been assessed and on what standard? If the assessment's been done on an on-farm by on-farm basis like we had to for Gallo and Williams, then I can say, okay, there's been a pretty good assessment. There's no way that's happened. So what's the level or the standard that had to be met to make the assessment that there was going to be this sensible allocation of water? The other thing that happens is if you have a catchment which has a new plan prepared for it and you actually wanted to go out and get a consultant to actually do that assessment properly, there aren't enough consultants in Queensland to enable everyone to do it. There's just too much work to be done. So you can't kind of do it in the timeframes that are permitted anyway. Other things that really come to the fore is that there's often a lack of recognition of your skills and knowledge having worked on the farm for a long period of time, or your generations of being on the farm. So all of these broad brush assumptions that get made don't give me confidence about how we make plans in relation to water. And one of the things that sometimes gets relied on is prior history of use. Well, sorry, people change their plans. Uses get changed. I said I was going to talk a little bit about the allocation of water. You've got 1,000 unsupplemented water licences in the Mary Valley, and they're talking about taking those over to volumetric licenses. What evidence was put forward to say that that water was either not or was being efficiently used in the first place to take that from someone? I've had clients who have had area-based licenses and they have had multiple crops rotated through the year on their property and they farm it well and efficiently. Others don't, some do. When someone's doing that and they base their business modelling on the basis that they have an allocation for an area, not a volume, then in those circumstances, they're being prejudiced. They're being prejudiced in circumstances where it's really hard to put material together into a plan-making process and have that overturned. A lot of these things seem to me to have been almost preordained. I'm not going to give up, but I'm not confident about changes being made. So we have to try and challenge these plan-making processes and we have to try and drive them in a way that's sensible. So again, just what standards are being put forward? They've got to rely on submissions. I don't think the standards are good enough. So moving to another series of planning documents where water's important. Darling Downs Regional Plan, talking about Condamine alluvium. Water resource and water supply planning are undertaken through a number of areas, and therefore in the Darling Downs Regional Plan, we're not going to assess water. That's a key issue, right? It doesn't stand on its own because of the interrelationship between plans. So if the Darling Downs Regional Plan is not going to deal with water, how does it deal with the priority agricultural areas and the priority agricultural land uses, UPARs and UPALUs? It says we're going to give them priority over the resource industry. Okay, well, you're going to give them priority, but how do you do that if you can't tell me what's happening with the water? There's a disjoint in that. So this document, the regional plan, doesn't deal with water, and I can't work out how the two fit together. We then go on to the Regional Planning Interest Act. And have a look at paragraph C. The purpose of this act is to manage, including the ways identified in regional plans. Yeah. The regional plan doesn't identify the association with water, the impact of the resource activity on the area of regional interest, the coexistence in the areas of regional interest of resource activities and other regulated activities. It can't work. That regional plan doesn't address water. The Regional Planning Interest Act tries to pick up the regional plan to give it the teeth to do something about that priority of agriculture. There's a disjoint. So we've got planning which is running through several layers, which just doesn't marry up. So again, coming back to that basic question, does our law provide an adequate regime? In my view, no, it doesn't. We need some changes to our law. So when we first started looking at coal seam gas industry coming in, the state and the Commonwealth governments all set out processes and said, look, we need some science, we need some evidence. And the initial policy said, look, prior to the licenses being given, we need some independent expert studies. Independent? Question mark. It's to do with connectivity of groundwater and those sorts of impacts that we need to look at. The Geoscience report of 29 September 2010 said further work was required. It was useful preliminary assessment. So this is before the industry is really kicking on. We're talking about its genesis. Insufficient information to assess the impacts. Insufficient information relative to the significance of the proposed coal seam gas activities in proportion to recharge to individual Great Artesian Basin aquifers. Additional data is required. We go again to the same report. Current groundwater modelling is inadequate. It should be possible to manage the groundwater impacts, proposed and potential future coal seam gas extraction, and minimise the risk of unintentional outcomes. The standard that was applied there was, we don't know, we haven't got the modelling right, but we're going to go ahead anyway. The water allocation for the farmer, I had to prove everything. Huge gulf in the standards. This was something that was in the earlier report. I never understood the significance of it until the recent issues to do with subsidence. So based on our assessment of geological and geotech information, we could have a result in surface subsidence. When you go down, it indicates that we knew back in 2010 that there was this risk of subsidence. And there was monitoring requirements that were indicated. Now, one of the things that I'm going to say at the end of this is that I think we should be looking for the monitoring information that was put in place in relation to that subsidence, because it's got some very broad issues, and that might be right to information to various governments and agencies. When they allowed the coal seam gas industry to go ahead, part of the rationale for that was, look, big industry, broad area, will have an adaptive management regime. As a lawyer, I know what an adaptive management regime should have. It should have lots of different fallback positions so that if one thing doesn't work, you can fix it up doing another or another or another. The adaptive management was re-injection, and that's significantly not worked. The next level was, well, make good. That make good's not actually fixing the problem up. All it's doing is shifting it. It isn't actually an adaptive management regime. So, I would have loved to have gone to the court in Gallo and Williams and said, I would like an adaptive management regime. And you know what? In that case, it could have been quite sensible. We're talking about an aquifer that fills in tens of years, not hundreds of years. The damage we do to the Great Artesian Basin is going to come out 80, 90, 100 years down the track. I could monitor much more closely what was happening in the tablelands. But anyway, so this is a New Zealand authority which sets out some pretty basic principles in relation to an adaptive management regime. First question, A, the extent of the environmental risk. The environmental risk is we're going to stuff up an aquifer which is actually in the driest habitated continent in the world, and we're going to stop people being able to produce water. We're going to stuff up the environment where they've got perch lakes. There's a whole raft of risks. Tick that one as really high. The importance of the activity. Okay, getting energy is an important activity. Got no problem with that. I think they passed that test. It was very important. Next one, the degree of uncertainty. Well, you saw those extracts I took out of the reports, insufficient information, no data. There was a huge degree of uncertainty. And then the last one, the extent to which an adaptive management approach will be sufficient to diminish the risk. We had one option really on the table and it hasn't worked. Typically the adaptive management regimes have several options. Most of that law has come out of stuff that I've read in the US where they've been talking about impacts on reserves and parks with access to tourists. And there's ways of managing that. That's really sensible for an adaptive management. If at the end of the day it's not working, you stop people going in there. But you haven't actually stuffed something up in the sense that we can here. So again, coming back to the sort of thing that occurred, we had a desktop study. There was lack of sufficiently detailed numerical modelling outputs and lots of other bits and pieces. So we jumped to Arrow. So Arrow indicated in their environmental impact statement that there was going to be a maximum predicted drawdown of 150 metres in relation to the coal seam gas groundwater in relation to the Walloon coal measure. Okay, okay. This is my law. Unlimited take of water from a resource company. Unlimited. At the same time that the water plans for these areas are saying, farmers, you're taking too much water, you don't have enough for environmental flows, we don't have this, that, and the other thing. There's an interconnection between aquifers and surface water. Same time that's happening. The big thing about the Artesian Basin, and you will know this better than I, it's pressure. You need the pressure to get the head of water up. Sometimes that pressure is good enough to take the water to the surface, but in any event, there's that pressure that's needed to hold the landmass above it, and this is where this subsidence of surface is coming from. So we reduce the pressure. This might not be clear enough to scale. Toowoomba, I can't even read from here, Roma. So this is the area of predicted impact. The green runs from 1 metre drawdown, yellow's 150, red goes up to 700 metres drawdown. That's the drawdown in pressure in the aquifer. Walloon coal measure. This is out of a report dealing with the Walloon coal measure. The height between here and here, so this area in here is the Condamine alluvium. the height between there and there is about 140 metres. We were talking about 150 metre drawdown. The line here is the head of pressure present prior to the gas industry operating. So you can see it runs across there. That is the water surface level in the Condamine alluvium. So anywhere along this stream where there is connectivity, and we all know that there's connectivity in various reaches of that river. We've seen the gas bubbling out of the river, so we know that there's connectivity. If I'm going to drop the head of pressure from there down to there, a reach that was previously receiving water will no longer be receiving water. Water will be going the other way. So we know that there's going to be impacts in relation to that. When I first saw this stuff, I actually thought of the surface water rights only, because I hadn't realised the subsidence impacts. But even on the surface water rights, you're running your cattle down to the stream to get water, it's not there anymore. It runs dry. Was that climate change or was that depressurization? You know, so we've got this myriad of explanation without sufficient detail to go through the evidence that's available. And we know that this evidence is there. So in 2016, after we've been doing this work for a while, the Underground Water Impact Report said there would be 459 bores affected long term. By 2021, we're up to 702. We got that really wrong, didn't we? 33% sort of thereabouts variation, and we haven't finished yet. %50 recovery from the maximum impact, whatever that maximum impact is, whenever that occurs, may not have occurred yet. I don't know when it's going to occur because I haven't got the science for it. 30 to 80 years after the maximum impact. So we're talking a long term. So you know that case about adaptive management, how the hell can you apply that in circumstances where you've got this on land that's prime agricultural land? And it's recognised in the regional plan as being priority agricultural land. And yet I'm still going to take water away from it. That is just frustrating. Okay. So this is out of the 2022 report in relation to the coal seam gas-induced subsidence. It allows the seams to compress under the weight of the overlying formation. See that part in the middle of the first paragraph? Allows the seams to compress. I didn't realise that. So, not a good way to think of an aquifer, but if you think of an aquifer as having a depth like a bucket, you've got that much space to put water in, okay? If that's compressed, I don't know how far it's compressed, but let's say it's halfway. My bucket forever forward is half what it was, or whatever that compression rate is going forward. That is a long-term, irreversible impact. And yet, our water planning documents talk about making sure we don't have impacts that are not reversible. And yet here we've had the government exercising its powers because of the drunk on royalties component, allowing this to happen to an asset which is one of our most fundamentally important assets in this driest continent. So we're crushing the bucket. So that's never ever going to go back to how it was. This case, very briefly, this and the next PowerPoint really say we're going to look at make good. We all know what that is. It's I'll pay you some money or I'll put a bore down to a different well, provide you water somehow. Also it says that there was no evidence provided of certain impacts, but because the party opposing the grant of the mining application didn't produce any evidence about it, we're going to allow it to go ahead anyway. It's kind of the reverse onus to what the allocation position is. So both of those do that. So, we've got deficient studies, lack of evidence. I haven't really explained that, but there has been very few enforcements. And when enforcement action has been brought in relation to activities outside of your jurisdiction, I've defended farmers in relation to taking some megalitres of water, but when it comes to a major company actually mistreating this really valuable resource, lack of enforcement, adaptive management doesn't apply because it's not suitable in the circumstances. We're reducing the pressure. So we've got all of these things that are problems going forward. I said to you that it was important that we contemplate the fiduciary duty that is given and think in terms of what steps we need to take going forward. I think we need to make lots of submissions in relation to legislation. I'm not going to tell you that I'm optimistic that government's going to change, but I think you've got to keep hammering it. And the thing is, you don't give up. You keep on trying and trying. We should be doing things like calling people to account. So where those mining companies, resource companies were obliged to monitor the impacts of subsidence, I've not seen any of that material. I've not seen it come into the public realm. I would really like to see that. So right to information, let's see what documents you get in relation to those sorts of things. Make submissions in relation to the standards. When we're talking about preparation of water plans for a particular area, the typical consultation that occurs isn't good enough. You need a better model of consultation, not a preordained, this is what we think should happen and now please agree with us. So it's not so much optimism going forward, but thinking about things you can do. One of the things that I did see, we go to the last one, that I've seen these used in relation to broad planning, where I think the primary use is to allow mining activity to continue, but I actually tried to see if there was any of this long paddock information available for properties in the Mary Valley, and I just hit a couple of properties and it wasn't available. But as a overview position in relation to looking at how frequently crops were watered and grown on the property, that was a quick desktop way of looking at it by actually looking at aerial imagery over a sequence of photos over years, and then being able to say, well, you know, we've got a green flush, we've got a green flush, we've got a green flush. Possibly that means that there's a certain number of crops grown. So those of you who have got allocations area-based rather than volumetric and are being pushed toward volumetric, maybe that sort of information is the information that should go into any submission that you've got, because at least it gives you some basis for saying, well, it was used and it was frequently used.